I found myself Googling the 14th Amendment yesterday before I interviewed Judge Ludig. So let me, he actually sent it along to aid me. Let me read it to everybody. 14th Amendment, Section 3, which he referenced there. No person shall be a senator, a representative in Congress, or elector of president and vice president, or hold any office, civil or military, under the United States or under any state, who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each House, remove such disability. Mark Elias, tell me your thoughts on the sort of Ludig tribe theory argument.
Yeah, look, I think it's unquestionably correct. This has become an increasing consensus. I actually wrote something for Democracy Docket just within a week of January 6, 2021, in which I called for Congress to immediately expel a significant numbers of members of Congress who I think violated this clause and were no longer eligible to hold office. And I continue to think they no longer are eligible to hold office. If you look at, for example, you know, the activities of Josh Hawley holding up his his fist rather, in support of the insurrection as it was going on, you know, is that not providing aid or comfort to insurrectionists? And certainly the role of the former president clearly qualifies as disqualifying him. But to be clear, it's not just people like me, it's not just people like Judge Ludig or Professor Tribe. Two very conservative Federalist Society professors, in good standing Federalist Society professors, recently wrote a very persuasive law review that said that Donald Trump and probably others, including members of Congress, are disqualified under the 14th Amendment from holding office, and they should not be allowed on the ballot.
So let me keep going. Let's go as deep as we can on this idea. It was riveting when he put it out there, but we sort of spent the last 24 hours doing some of our homework. And I want to read this from the piece that Judge Ludig and Professor Tribe write to you, Mark. The disqualification clause operates independently of any such criminal proceedings, and indeed also independently of impeachment proceedings and of congressional legislation. The clause was designed to operate directly and immediately upon those who betray their oaths to the Constitution, whether by taking up arms to overturn our government or by waging war on our government by attempting to overturn a presidential election through a bloodless coup. Now, this wasn't even that, but I just want to put everyone in a time capsule and show you who the two Republican leaders in Congress blamed for January 6th. This is Kevin McCarthy and Mitch McConnell.
The president bears responsibility for Wednesday's attack on Congress by mob rioters. He should have immediately denounced the mob when he saw what was unfolding.
January 6th was a disgrace. American citizens attacked their own government. They used terrorism to try to stop a specific piece of domestic business they did not like. There's no question, none, that President Trump is practically and morally responsible for provoking the events of the day. No question about it.
So again, I play that because the facts are not in dispute. What we need a therapist to come on and explain is how both those men plan to vote for Trump if he's the nominee, but we'll do that another day. Today, in terms of establishing the facts to sort of apply the Section 3 of the 14th Amendment, the facts are not in dispute by anybody, Mark.
I think that's right. And I also think that it is not in dispute if you look at the history of the 14th Amendment, how it came to be, and its plain text, that it is self-effectuating. In other words, there's no role for Congress to play in having to pass a law because there is a constitutional amendment that has text, so you don't need a separate law. There's really no role for the courts to play in the sense of requiring a criminal conviction. The 14th Amendment doesn't speak about people convicted of offenses. It is self-executing in that a person in this instance, the former president and others, who engaged in insurrection or gave aid and comfort, they are simply disqualified. They are simply not eligible to hold office. And so the only question is whether or not the secretaries of state and the other state officials whose responsibility is to uphold the Constitution and apply it in the same way that they would apply an age restriction or a residency requirement for, or an inhabitancy requirement, whether or not they're going to do that here, because the former president is simply not eligible to be on the ballot for president in 2024.
Yeah, interestingly, Mark, Judge Ludig made that analogy. He said it's like the requirements. You have to be 35 years old. It's black and white. Secretary Benson, let me show you what your counterpart in Georgia, Brad Raffensperger, said about the obligation of someone in his job, in your job, to follow the Constitution.
Mr. Secretary, why didn't you just quit and walk away?
Because I knew that we had followed the law and we had followed the Constitution. And I think sometimes moments require you to stand up and just take the shots when you're doing your job. And that's all we did. We just followed the law and we followed the Constitution. And at the end of the day, President Trump came up short. But I had to be faithful to the Constitution. And that's what I swore an oath to do.
So, Secretary Benson, I know this conversation is in its earliest stages with sort of the legal framework being put out there just this week by Judge Ludig and by Professor Tribe. But what questions would you have if this is indeed what the Constitution would require folks like Mr. Raffensperger and yourself to do?
Well, thanks, Nicole. I think that's the right way to frame it right now. And first and foremost, I want to be clear. I'm going to follow the law. What the law says is what is going to dictate how I hope all of my colleagues proceed in this moment, in particular around thorny issues like this one. Now, in following the law, that means being very careful, making decisions not from a political standpoint, but from a legal standpoint, and asking questions like about due process. Now, typically, a conviction is used to determine the facts and solidify the facts when someone is deemed ineligible, when there are perhaps thorny issues at play. If we're not going to predicate this on a conviction under the law, then what and how do we ensure due process? How do we define insurrection or rebellion? Who makes that determination? And what potential guardrails do we need to have in place so that this is not this precedent that could be created if this legal interpretation is adopted? How can we avoid that being weaponized in the future in this era of false equivalency by officials who want to block candidates from the ballot simply because they disagree with them politically? So this is a really thorny, challenging issue. But and I should emphasize that particularly those of the secretaries in battleground states, I'm going to be talking with Al Schmidt in Pennsylvania, with Cisco Aguilar in Nevada, with Brad Raffensperger, because we know in particular in our states the impact that this decision could have, not just among our voters, but in the nation. And so we're taking this seriously, we're looking at it carefully, and we're weighing all of the thorny issues at play.
I mean, Mark, what is your sense? I mean, where would that direction and interpretation of the law come from? I mean, would you predict that a Supreme Court ruling on this would have to come down so that people like Secretary Benson and Secretary Raffensperger have clarity on what they are to do before they print their ballots?
So a couple of things. The first is, I think, we analogize too much in this country generally to the criminal law. The criminal law is meant to do a certain thing, which is to punish criminal behavior, which is why there's a presumption of innocence, why there is a requirement of proof beyond a reasonable doubt, right to a jury. There are all kinds of protections, as the Secretary put it, due process, that are put in place for the unique process that can, after all, deprive someone of a liberty interest, right? Someone not being allowed to run for federal office is not being deprived of a liberty interest. They're not being thrown in jail for it. So we need to be careful about establishing a burden here that really doesn't exist in this provision of the Constitution. But I do agree with the Secretary that there are, you need to have guardrails and touchstones to look at to determine, was it an insurrection? Did the person engage in insurrection or provide aid or comfort to the enemies thereof? Those are factual determinations that I agree have to be hashed out. And to answer your question directly, I have no doubt, as Judge Ludig said, eventually the courts will have to hear any challenge. They may hear a challenge by a candidate who has deprived access to the ballot. They may hear a challenge if they grant access to the ballot that they wrongfully allowed the person on the ballot. So I think it can go either way, but I suspect eventually the courts will be involved in sorting it out.